untold, and the chat's got soul. From the gavel to the gas, we're watching it all. Covering the courtroom, big case or small. Laugh when we can, cry when we must, but it's all real talk, you can count on us. We're not the pros, just fans who care. With popcorn in hand and a comfy chair. And every twist, we're right there. Together like we're all in the witness chair. This is the Broken Baker, where the trials come alive, where the chat is wild and the vibes survive. We're watching the worst of what people do, but we keep it light, yeah, that's our truth. It's the only place for crime, and it feels just right. We bring the justice talk into your night. So hit that stream, don't miss the call. At the Broken Baker, we cover it all. Oh yeah. We're just framing with the view, but we ask the things the world wants to. Digging through the facts, side by side. Even when it's dark, we bring the light. No clickbait, no fake feels, just truth and the highs and the reels. With the chat that roasts and rise, we're just here for the case and the vibe. This is the Broken Baker, where the stories unfold. With a smile in the heart, even when it's cold. Yeah, we cover the bad with a wink and a grin. Where the real talk starts, come on, jump in. It's the only place to be, can't you see? For trials and truth, it's BBTV. The Broken Baker, where the trials come alive. Yeah, we'll be here, trial and trial. Yeah.
Magnus, og du er en gammel kone, du skal alligevel op ad nattis, så du kan lige blive op en time længere. Men dejligt at se dig igen. Det er et stykke tid siden, jeg har set dig i chatty. It's the most beautiful language in the world. It's Danish. So, I just got sent the motion to dismiss from the Karen Read trial that was filed, it's just been filed today on the docket, but it seems like it's been, Marissa said something. Yeah, Marissa always says something. The first motion to dismiss was dated July 9th, but it only went to the docket today. We have the O'Keefe family's reply as well. So they, of course, will say, hey, she can't dismiss this. She's evil. And then we're going to get to the Karen Read response to the O'Keefe response. And that's a little spicy meatball. Så har du haft masser af tid til at kigge. Hello, Sue. And I'm just stalling a little bit to see if more people want to join us reading this, because I think it's we all know what this is about, because I read the original civil suit against Karen Read. It'll be repeated a lot in this, so I'm going to skip reading the civil suit. It's just that Karen Read did all of these things, and that's why she needs to pay the O'Keefes. And the Waterfall and C.F. McCarty's needs to pay them as well, because nothing can bring back John O'Keefe, who his mother didn't talk to, whose brother didn't want to take the kids. Nothing can give them solace as a big fat paycheck. That is, of course, why they are suing, because they really want to remember their son. Three streams in one day. 4. Jamie must be around the corner. She's always around with a baseball bat. It's been forever and a day since I've seen you. Yeah, I can't remember the last time I even talked to you. Kink i nakken. Oh, Well, my Winosaur, she's kinky in the neck. But let's jump into it. If more people want to join us, they're welcome. So this is Plymouth SS. The O'Keefe, Paul O'Keefe, as personal representative of the estate of John Joseph O'Keefe III, Paul O'Keefe individually, John O'Keefe II, Margaret O'Keefe, and Margaret O'Keefe as grandparents, guardians of, I won't mention her name. And they are suing C&C Hospitality, that's CF McCarty's, GS Hospitality, CF McCarty's, Waterfall Bar and Grill, and Karen Reed. And defendant Karen Reed hereby files the written memorandum of law in support of her motion to dismiss counts 10, 11, 12, and 13 of the plaintiff's complaint pursuant to Massachusetts Civil Procedure 12. The counts sought to be dismissed are as follows. Count 10, Margaret O'Keefe versus Karen Reed, negligent and or reckless infliction of emotional distress. Count 11, the same. Count 12, the same, just against John O'Keefe and Paul O'Keefe. Count, that's against the daughter. As a matter of law, the plaintiffs have not, nor can they state a claim upon which relief can be granted insofar as any distress claims are subsumed by the wrongful death statute. None of the plaintiffs can recover for negligent infliction of emotional distress based upon the occurrence of the alleged incidents because they were not at the scene, nor did they witness an immediate consequence to the decedent. The allegation in the complaint concerning the circumstances of the alleged incidents and the defendant's purported statements and actions in the hours after the alleged accidents cannot support a claim of intentional and or reckless infliction of emotional distress. Accordingly, and for the foregoing reasons, count 10, 11, 12, and 13 of the plaintiff's complaint should be dismissed pursuant to Massachusetts Civil P12. Relevant allegations in the plaintiff's complaint. The following allegations are taken from the plaintiff's complaint and are presented here in a light most favorable to the plaintiffs pursuant to the legal standard. They should not be misconstrued as admissions by the defendant. The defendant vehemently denies that she is liable to the plaintiffs, as there was no collision between defendant's SUV and John O'Keefe, leading to his injury and death. And then we are going back to the entire first filing from the O'Keefe family. And it's just a rehashing of what we saw in the trial, except they further allege the defendant knowingly and deliberately changed the story and fabricated a conspiracy knowing the same to be false. So how can they prove that? That's going to be interesting. The complaint alleges that Margaret O'Keefe is the decedent's mother, John O'Keefe is the decedent's father, Paul O'Keefe is the decedent's brother, and Katie, no, I'm not going to mention that name, is the niece. Margaret O'Keefe, John O'Keefe, and Paul O'Keefe claimed that they came upon the decedent's body at the hospital. All plaintiffs allege that the defendant created a false narrative. Standard of review. Massachusetts Rule P12 provides that the defendant may move to dismiss a complaint if it fails to state a claim upon which the relief can be granted. In evaluating the legal sufficiency of a complaint under P12, the court must accept as true all of the factual allegations in the complaint and draw all reasonable inferences from it in favor of the plaintiff. Nevertheless, the court needs not accept as true any legal conclusions that are presented under the guise of being factual allegations. To survive a motion to dismiss, a complaint must contain factual allegation which, if true, raise a right to relief above the speculative level and are not simply consistent with an entitlement to relief. A complaint must contain more than labels and conclusions, and a formulaic recitation of the elements of cause of action will of the elements of a cause of actions will not. I don't understand that. Argument. Margaret and John O'Keefe's distress claims are subsumed by the wrongful death statute. The complaint does not identify that the decedent's passed with a spouse or child, meaning the person is entitled to any wrongful death damages as are the next of kin. Pursuant to GLE 190B, the next of kin are the decedent's parents, plaintiff Margaret O'Keefe and John O'Keefe. With respect to claims that may be asserted on behalf of the decedent's parents as the next of kin, states in part, a person who by his negligence causes the death of a person shall be liable in damages in the amount the fair monetary value of the decedent to the persons entitled to receive the damages recovered, as provided in Section 1, included but not limited to compensation for the services, protection, care, assistance, society, companionship, comfort, guidance, counsel, and advice of the decedent to the person entitled to the damages recovered. Here, plaintiff Margaret O'Keefe and John O'Keefe allegedly experienced an emotional reaction caused by the death of their son. As the next of kin, their claim for loss of consortium are factored into the decedent's estate wrongful death claim and may not be duplicated as part of any claim for emotional distress. Emotional distress existing from circumstances other than the actions of the respondent or from a condition existing prior to the unlawful act is not compensable. The complaint fails to distinguish or otherwise delineate the alleged harm caused to Margaret O'Keefe or John O'Keefe between loss of consortium and other emotional distress. Count 10 and 11 of the complaint should thus be dismissed. See Exhibit A. Alleging the plaintiff suffered aggravated emotional distress, alleging defendant's negligence caused their son's death as the basis for emotional distress claims. The plaintiff's emotional distress claims fail as a matter of law. The complaint title counts 10, 11, and 12, negligent and or reckless infliction of emotional distress, without providing context for what conduct within each count applies to what claim. The elements of reckless infliction of emotional distress are markedly different from that of negligent infliction of emotional distress because reckless infliction of emotional distress contains the same elements as those for intentional infliction of emotional distress. To prevail in a claim for the intentional infliction of emotional distress, the plaintiff must prove that the actor intended to inflict emotional distress or that he knew or should have known that emotional distress was the likely result of his conduct, that the conduct was extreme and outrageous, was beyond all possible bounds of decency, and was utterly intolerable in a civilized community, that the actions of the defendant were the cause of the plaintiff's distress, and that the emotional distress sustained by the plaintiff was severe and of a nature that no reasonable man could be expected to endure. To prevail in a claim for the negligent infliction of emotional distress, the plaintiff must prove negligence, emotional distress, causation, physical harm manifested by objective symptomatology. Sorry, that word is hard. And that a reasonable person would have suffered emotional distress under the circumstances of the case. The complainant's failure to specify the factual allegation in support of the different emotional distress claims warrant dismissal, or at the very least, a more definite statement pursuant to Massachusetts P12. The argument aside, counts 10, 11, and 12 appear to claim reckless infliction of emotional distress based on the defendant's alleged formation of a false narrative and the negligent infliction of emotional distress based on certain plaintiff's observation of the decedent's body in the hospital after 7:50 a.m. on January 29th. As set forth below, the complaint fails to present a cognizable claim for emotional distress. The plaintiff's cannot present a claim for negligent infliction of emotional distress because their claimed distress was not contemporaneous with the alleged accident. No plaintiffs directly witnessed the defendant's alleged negligent conduct, the alleged vehicle strike that is claimed to have occurred between 12:11 a.m. and 12:36 a.m. on January 29th, or the decedent himself until at least 7 hours after the incident. Massachusetts recognized claims for emotional injuries by parents and close relatives arising out of their witnessing an accident to a loved one, but the plaintiff must show substantially contemporaneous knowledge of the outrageous conduct and a severe emotional response. Only a bystander plaintiff who is closely related to a third person directly injured by a defendant's torturous conduct and suffers emotional injuries as the result of witnessing the accident or coming upon the third person soon after the accident states a claim for which relief may be granted. The close proximity of time between the alleged harmful event and a plaintiff's claim for emotional distress must be near instantaneous. And they say, see Cohen v. McDonnell Douglas Corporation, a mother who learned of her son passing by telephone 7 hours after the event and was not at the scene of the event, could not pursue a claim for emotional distress. Here, Margaret, Paul, and John O'Keefe each alleges that some time after the decedent was transported to the hospital, at least 7 hours after the alleged vehicle strike, based on the factual advertisements, they observed their adult son brother's body in the hospital. There is no allegation that any plaintiff observed the alleged vehicle strike itself or that the plaintiffs were within the vicinity of 34 Fairview Road when it occurred. Moreover, the plaintiffs claim shock was not experienced immediately after the occurrence, but rather at least 7 hours later, removing it from the scope of requisite temporal proximity. See Migliori. Courts have imposed rational, temporal, and spatial limits on the scope of liability for emotional harm. Ferrier v. Daniel O'Connell, shock occurred immediately after the accident. The complaint contains no allegation that plaintiff, won't mention that name, directly observed the alleged conduct that caused the decedent's death, nor did she observe the decedent at any point thereafter. The alleged perception of death, as alleged, was based on conversations with the defendant, and there is no precedent for one to claim emotional distress as a bystander merely by learning via conversation that a loved one has been injured or passed away. Because the complaint fails to present a claim that the plaintiff's claimed emotional reactions occurred contemporaneously with the alleged tortious conduct or immediately after, their negligent infliction of emotional distress claims has no legal basis and should be dismissed. Well, so far she is motioning to dismiss. You look worse. Paul was blowing kisses. He was so upset. Maggie was saying, what's she doing here? Yeah, they were highly emotional distressed. The claim for reckless infliction of emotional distress fails because there was no extreme or outrageous conduct directed towards the plaintiff that resulted in severe harm. Plaintiffs each alleged that the defendants outrageously created a false narrative. There are no allegations that the claimed conduct was performed by the defendant with such reckless design to cause emotional suffering to the plaintiff. The defendant's statements in which she questioned and or denied striking the decedent with her vehicle, allegedly creating a false narrative, or speculated that a snowplow may have struck the decedent, do not rise to the level of intent toward the plaintiff. See Nancy P.V. Diamatro. Moreover, putting aside that she was successfully defending herself against unproven and false criminal charges pending in the Norfolk Superior Court, the plaintiffs claim that the defendant's conduct after the accident was extreme or outrageous fails as a matter of law. See Polay v. McMahon. Finding the allegations of verbal attacks, filing false police reports, and harassment petition did not rise to the level of extreme or or outrageous, and the person bringing suit must show that the petition activities lacked any reasonable factual support or arguable basis in law. Liability cannot be predicated on mere insults, indignities, threats, annoyance, petty oppressions, or other trivialities, nor even is it enough that the defendant had acted with an intent which is tortious or even criminal, or that he has intended to inflict emotional distress, or even that his conduct has been characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. The complaint contains no factual averment that identifies the substance of the alleged false narrative and how it was outside the bounds of all possible decency and utterly intolerable in a civilized community such that the plaintiff may pursue an emotional distress claim. Without requisite factual averment, I don't know what that word is, the complaint fails to present a cognizable claim for reckless infliction of emotional distress. The name I won't mention, claim for emotional distress, fails as a matter of law. Within count 13, the plaintiff niece asserts multiple claims for emotional distress, but does not ascribe where conduct applies to what type of claim, i.e., negligent versus reckless versus intentional inflictions of emotional distress. Plaintiffs allege that the defendant spoke to a third person on a speakerphone in niece's presence, waking her up, in the process notifying her that something might have happened to the decedent, and inferring that the niece perceived the decedent's death. The plaintiff also alleges that the defendant feigned concern for the family and drove her SUV away from the decedent's residence after the decedent was declared dead. Finally, plaintiffs again alleged that the defendant created a false narrative. For the reasons previously stated and as set forth below, the complaint fails to state any cognizable claim for emotional distress upon which relief can be granted to the niece. The defendant alleged conduct identified by count 13, feigning sincerity and driving her SUV away from property that the defendant allegedly did not own or control, does not rise to the level of conduct that would be considered so outrageous and extreme that it would be considered utterly intolerable in a civilized community. Moreover, the defendant's questioning what happened during a phone call with third parties, even if in plaintiff's niece's presence, is also not actionable conduct. To the extent the complaint repeats and restates various elements to establish a claim for emotional distress, actual factual averment, are necessary to support of these elements to prevent the motion to dismiss. See Polay. A complaint contains only conclusory statement that the emotional distress suffered by plaintiffs were severe and of such a nature that no reasonable person could be expected to endure it. This statement does not constitute an allegation of facts, but rather a recitation of the elements of severe emotional distress. For the above reasons, the niece's claims for intentional, reckless, and negligent infliction of emotional distress fails as a matter of law and must be dismissed. Conclusion. For the reasons stated above, the defendant, Karen Reed, respectfully requests that the Honorable Court allow the motion and enter an order dismissing counts 10, 11, 12, and 13. Supplied by William Kerville Jr., Christopher B. George, Marissa K. Palladini, Merlick, and Porter. That's her lawyers. Dated July 9th. That was a long one. But what it is surmised is they weren't there. They didn't see him until he was in the hospital. So claiming anything was an intentional or unintentional emotional distress has no bearing, because the law states that they must be imminent or observing the accident. So, Bizarre that they don't sue the Alberts. Well, they don't have any claims to sue the Alberts because the Alberts has nothing to do with the alleged accident. Yes, I can't see the niece reaching the conclusions, but I can see why you want to smack a child in front of a judge crying, just like Brennan and Lally did, because they want to pull on the emotional heartstrings. And this is a civil court, so the bar is lower. Tears works really well to grease a civil court. That's why they have to get as much as it out before you go in front of the civil court. Yes, she clearly has, and I am pretty sure that she don't know anything about what is alleged in her name, because this seems like it's mommy and brother who want to get paid. Of course, to help the kids further in life, because that GoFundMe money is put in an account so they can go to college, right? Hey, Dodo. The Alberts still have all their money, though. Well, the Alberts didn't drive any car that is alleged to have struck John O'Keefe, so that's why they can't sue the Alberts. You can't just sue people because they were there that night. Are they allowed to use the criminal court decision as an argument for innocence, seen as the bar is much higher? No. Well, they can mention that she potentially, but O.J. Simpson was found innocent in criminal court and guilty in civil court. So it's a different set of rules that you're playing with, and the bar is way lower. Instead of beyond reasonable doubt, it's just 50.00001% think she's guilty. She's guilty. And again, if you can put a human face on the suffering, maybe a 16, 17-year-old kid crying on the stand, really greases civil suits. I don't know if can they even mention it, that she was found not guilty. I don't know. It's not logic in your mind. No, but that's because you're Danish. If Paul wanted the money for the kid, then he shouldn't have used the insurance money to expand his house. We still don't know any of that because we don't have any insights into his economy. But I just hope, didn't they do a GoFundMe that raised like $250,000-$300,000? I hope they are all in a account that makes sure that, oh, what the hell did I get in my eye? That the kids can go to college. But of course, the O'Keefe family response. Karen Reed inaccurately styled her motion as a motion to dismiss the plaintiff's complaint, when in reality it only seeks to dismiss several counts, sounding in emotional distress, knowing that the media would pick it up on the 9E filing. The case focused on the tragic, wrongful death of a beloved Boston police officer and the catastrophic loss of the deceased close family members left behind. The plaintiff, in this case, the parents, brother, and niece of the decedent, blah, 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 alleged that the defendant, Karen Reed, while drunk driving, Karen Reed served her motion to dismiss on or about July 9th, on or about July 25th and July 29th. After having answered plaintiff's complaint, defendant Waterfall Bar and Grill and C.F. McCarty sought to join Karen Reed's motion to dismiss in adopting the same arguments raised by Reed. For the same reasons articulated herein, the bar defense motion should also be denied. Alleged that the Karen Reed, while drunk, struck John O'Keefe with her SUV and left him gravely injured to die outside alone in emerging blizzard conditions. Well, this part, this part should be struck because they can't prove anything about an emergent blizzard because he was removed before the blizzard started. Instead of calling for help during those critical early mornings, plaintiff alleged that Reed awakened JJ's 14-year-old niece in a panic and exploited her as part of Reed's attempt to deflect and frame a false narrative around JJ's death. The O'Keefe family has suffered and continues to suffer immense emotional trauma from this wrongful death, which has been further intensified by the unyielding barrage of harassment and ridicule by Reed and her supporters targeting the grieving family. Who is making a motion for the media? You are making a motion for the media. There was nothing in the first motion I just read that in any way was good to do sound bites on. This bullshit, this is made exactly for friendly newspapers to cut all of this out, for Krusty Panties to go on the Twit thread today and talk about how she's still harassing the family. Give me an effing break. Claiming she does it for the media and then you file this bullshit? No one has proved anything close to this, that Karen Reed ridiculed the family. When? And what supporters are targeting the grieving family? Who is targeting the grieving family? No lawsuits filed against Aiden from the family, right? That's all the McAlberts. Just because we don't like Peg O'Keefe because she seemed a really big a-hole to her husband, that doesn't mean that we are targeting a grieving family. Go F yourself. You are the one writing a motion that you want shared on the Twit thread. Sadly, that's how it is. Reed's campaign of disinformation designed to obfuscate the truth and attack the O'Keefe family not only deprives them of justice, but also amplifies their grief and the loss of their beloved family member. They weren't even mentioned in the third-party culprit talks. None of it. None of it is true. Reed and her family went to great lengths to obtain orders from this court, shielding them from conveying discovery in this civil action during the pendency of the criminal matter. No, they didn't go to great length. This is normal procedure when you have a criminal case, as the civil case will be pushed. Who is the one who is making this for the media? I hope you can see it yourself. Well, you can, because you're the one writing this. The criminal case takes precedence over the civil case. I know you really, really wanted to have her do a interview with you, probably so you could leak that back to the criminal case, right? Try and sneak in a little violation of the Fifth Amendment, maybe. Who knows? I don't know. I'm just speculating. But you're claiming that she tried to go to great length. No, she just said, hey, I have a criminal case going on. And the judge said, yeah, go fuck yourself. You can talk to her later. Now that the stay has been lifted and the O'Keefe family is allowed to proceed, Reed asked this court to extinguish prematurely numerous legitimate claims made by the plaintiff, largely based on form over substance before any discovery occurs. The only issue that the court needs to resolve today is whether, assuming all factual allegations to be true and indulging every reasonable inference in plaintiff's favor, the complaint plausibly suggests that the plaintiffs are entitled to relief on the infliction of emotional distress claims. The answer to that question is a resounding yes. As will be demonstrated below, there is no bright line test for plaintiffs' infliction of emotional distress claims. Each claim requires an independent factual analysis on case-by-case basis, which cannot be resolved at this stage of the lawsuit or without adequate discovery. What? You can't determine if the family suffered emotional distress until you do discovery on Karen Reed? But didn't you claim that the emotional distress happened because of her striking him with a car? So you need to go and look into her phone to figure out if they were emotionally distressed? I'm not a lawyer. That doesn't make sense when you're a normal person. But hey, lawyers, you know. Whether the O'Keefe family suffered shock closely on the heels of Reed's action and JJ's death, or whether Reed's subsequently conduct rises to the level of extreme and outrageous, are questions prematurely raised to this court. See Ocasio-Hernandez v. Fortuno Burset, recognizing chain of events leading to defendant's action may often be unavailable to a plaintiff at this early stage of litigation. Wherefore, the O'Keefe family respectfully requests that this honorable court deny defendant Reed's motion to dismiss and allow the plaintiff an opportunity to conduct discovery, because the plaintiffs have averred plausible claims for relief against Reed for infliction of emotional distress. Relevant factual allegations. Plaintiff alleged the following facts relevant to the subject motion, which must be accepted as true and indulging every reasonable inference of the favor. And then we go through all the claims from the criminal case, that she had at least 9 alcoholic drinks over approximately 3 hours, blah, blah, blah. Thereafter, in a state of extreme intoxication, and blah, blah, blah. Blah, blah, blah. It's just everything you heard in the first trial. Reed worked the niece in a panic, stating that something had happened to JJ and that the niece's surrogate father was dead. All of this is something we have heard about, blah, 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 until we get down here. Thereafter, Reed deliberately fabricated a conspiracy and launched a public campaign of disinformation designed to obfuscate the truth and deprive the O'Keefe family of justice for JJ, which has caused severe and profound emotional distress to the already vulnerable O'Keefe family. Funny enough, we had a grand jury who looked into this conspiracy between Karen Reed and Aidan Carney. How much did they find? A grand jury where even the ham sandwich Brennan thinks is too much to give ARCA guys would be indicted. They didn't even indict Karen and Aidan for conspiracy. But hey, why let a good story go to waste when you can just fill it into your complaints like this? Argument. As discussed further below, the Honorable Court should deny Karen Reed's motion to dismiss because the allegation in the plaintiff's complaint, taken as true and constructed in the plaintiff's favor, state claims for relief that are plausible on their face, and plaintiff's infliction of emotional distress claims require a fact-intensive analysis which is not ripe for deciding at this early stage of the lawsuit and without adequate discovery. A plaintiff should prevail on a motion to dismiss under Massachusetts P12 if the factual allegation in the complaint assumed to be true, granting the pleader all reasonable inference that may be drawn from those factual allegations possessed enough heft plausibly to suggest that the pleader is entitled to relief. Ignacio v. Ford Motors. A complaint does not have to evince a one-to-one relationship between any single allegation or a necessary element of the course of action. Citation and quotation omitted. Rather, the plausibility standard should be applied to the claims as a whole. The critical question is whether the claim viewed holistically is made plausible by the cumulative effect of the factual allegation contained in the complaint. These generous and indulgent criteria has reduced a plaintiff's obstacle in surmounting a failure to state a claim to a minimal hurdle. It is a relative light burden to be carried in maintaining a complaint. 1. Negligent infliction of emotional distress is an independent cause of action, separate and distinct from wrongful death damages. As a preliminary defense, defendant Reed argues that JJ's parents, I hate they call him JJ, the O'Keefes, are precluded from asserting a negligent infliction of emotional distress claim. against Reed, because any emotional distress damages arising from the negligent infliction of emotional distress claim would be duplicative of the loss of consortium damages available under the wrongful death statute. Reed, however, cites no applicable case law to support her argument because no such precedents exist. The individual emotional distress damages recoverable under NIT are entirely unrelated to damages for the value of lost life under our wrongful death statute, which defendant refers to as loss of consortium. In fact, traditional emotional distress damages are expressly disallowed as a component of wrongful death damages. The legal principle is clear from plain language of our Superior Court model jury instruction on wrongful death damages to the next of kin, which state in pertinent part. In a wrongful death case like this one, a person who negligently causes someone's death must pay money damages to the surviving spouse, children, next of kin for the value of that lost life. For purpose of the wrongful death claim, the phrase lost value includes but is not limited to loss of reasonable anticipated service, protection, care, assistance, companionship, society, comfort, guidance, net income, support, counsel, and advice. Lost value does not include grief, anguish, or bereavement of DCD's death. No compensation for bereavement. While you must consider certain losses, such as loss of companionship and net income, you may not consider certain other things. Although losing a loved one is very difficult emotionally, the law does not allow NOK, any of the survivors, to recover damages for their grief, anguish, or bereavement. The monetary value of DCD's life depends upon the companionship, emotional, financially, or other benefits he would have provided to NOK if he had lived. Therefore, you must not award damages for NOK's grief, anguish, or bereavement. Superior Court Model Jury Instruction. A claim for damages based on emotional distress does not include an administrator's claim for loss of consortium, which will be present in every wrongful death such as this, since emotional distress is a wrong to the plaintiff's distinct from that done to his son and the statutory beneficiaries of the decedent. It is not a duplicative remedy and is not preempted by the wrongful death statute, Camino v. Milford. Distinguishing negligent infliction of death claims from wrongful death actions as severe psychological shock directly resulting from experiencing or witnessing the effects of a defendant's conduct. McCush v. Volkswagen AG. No provision for damages on account of the survivor's grief. Someone sued Volkswagen because probably someone got hit by a Volkswagen. Only in America. Bereavement or emotional distress and wrongful death action. In sum, the wrongful death statute creates a derivative right to recovery for statutory beneficiaries for the lost value of the decedent. Or, in other words, the loss of affection, service, financial support, and other benefits the decedent would have provided had she lived. In contrast, a claim for negligent death is an independent cause of action based on the individual claimant experience and or witnessing the consequences of a defendant's wrongful conduct, which permits recovery of emotional distress damages otherwise unavailable to beneficiaries under the wrongful death statute. Because the O'Keefe family claims for negligent death are independent causes of action, separate and distinct from the wrongful death claims, the defendant's motion to dismiss must be denied. Whew. It's a long one. Just checking if I lose something. John wasn't talking to his mother, no. So I don't know if you can use that to lower any monetary value that he didn't have. Also, you'll have to say he had a widowmaker in his arteries. Will that be something you can use in court? Because how long would he have lived with the blockage he had in his arteries? Are we entering into my world of civil fun? Well, Rubia, I don't know if this isn't. I'll say it when we have read the reply from the defense to the reply of the people who sued her. It's not that long. 55 pages, but that's with the exhibits. The complaint alleges sufficient grounds to hold Karen Read liable for negligent infliction of emotional distress. Karen Read cannot demonstrate that she is entitled to relief under Rule 12 as a matter of law based on the pleadings alone. Defendant argues that the O'Keefe family shock from experiencing and witnessing the consequences of Read's negligence was not sufficiently contemporaneous to support a claim for negligent emotional distress. That's what it is. Although courts have imposed rational temporal and spatial limits on the scope of liability for emotional harm, in this context, there is no bright line test that controls which claims are compensable and which are not. Instead, Massachusetts courts employ the traditional tort doctrine of reasonable foreseeability to govern bystanders' recovery, stating the determination whether there should be liability for the injury sustained depends on a number of factors, such as where, when, or how the injury to the third person entered into the consciousness of the claimant, and what degree there was a familiar or other relationship between the claimant and the third person. Dzietskonski v. Babineau, Moan v. Greyhound lines. Every effort must be made to avoid arbitrary lines which unnecessarily produce incongruous and indefensible results. Margaret, John, and Paul's emotional distress claims. Defendant attempts to draw an arbitrary line between the approximate time of Read's collision with John in front of Fairview and the time that the O'Keefe family subsequently observed John's lifeless body, without considering other relevant factors to argue that the family's negligent emotional distress claims fail as a matter of law. There is no requirement that the shock experienced by the O'Keefe family from the consequences of Read's negligence be immediate in a literal sense as suggested by the defendant. A plaintiff who rushes onto the accident scene and finds a loved one injured has no greater entitlement to compensation for that shock than a plaintiff who rushes instead to the hospital. So long as the shock follows closely on the heels of the accident, the two types of injuries are equally foreseeable. Ferreter v. Daniel O'Connell's sons. Holding trial court erred in granting summary judgment for defendant on plaintiff's negligent emotional damage claim, where plaintiffs first observed family members' injuries upon arriving to hospital, not at the scene of the accident, because as summary judgment, it may be inferred that the shock occurred immediately following the accident. Superseded by statute on other grounds, as stated in Sheehan versus Weaver. Furthermore, the proximity of the shock experienced by the plaintiff is neither anchored to the specific time of the collision nor the time of which the O'Keefe family first observed John in the hospital, but rather where, when, and how the injury to John entered into the consciousness of his family. Dzietskonski, see also Zachary v. Centrus Premier Home Care. In Zachary, a nurse negligently injected the plaintiff's father with an unknown substance, causing him injury. While the plaintiff's daughter learned of her father's injury the same day via telephone, she did not observe her father's suffering in person, nor learn of the nurse's wrongdoing until the following day. Acknowledging that the issue was a close one, the court denied the defendant's motion for summary judgment and permitted plaintiff negligent emotional damage claim to go forward to trial. Here, plaintiff's NIT allegations must be viewed through the lens of the Ignatiano standard, which is far more generous and forgiving than the summary judgment scrutiny applied in Ferrier and Zachary, where the court determined that the plaintiff's NIT claims should proceed to trial. While the collision between Read's SUV and John occurred sometime around 12:30, Read's wrongful conduct and consequences thereof continued into the early morning hours after. Read left John helpless and seriously injured in front of Fairview when she left the scene and returned to John's residence. Instead of calling for assistance while John lay suffering in freezing blizzard-like conditions, wrong, and we're going back to the same we have stated again. It was around this time the O'Keefe family immediately learned of John's injuries and admission to hospital. The O'Keefe family rushed to the hospital and came upon John's body only minutes after he was pronounced dead at approximately 7:50. It is abundantly clear from the circumstances where, when, and how the injury to John entered into the consciousness of the family that the shock experienced by the O'Keefe family followed sufficiently closely on the heels of Reed's alleged wrongdoing and the consequences to John to state a viable claim for the relief of Niet. Wherefore, defendant's motion to dismiss the O'Keefe family's Niet claims must be denied. And plaintiff's allegations are substantially more comparable to the circumstances of Ferrier and Zachary than the Niet case relied upon by defendant, none of which involved review of a motion to dismiss. On appeal from post-trial judgment, SJC affirmed no recovery for Niet or Niet, where mother did not learn about daughter's sexual assault until almost a year later. Maglioli, on certification of question of law from district court summary judgment motion, SJC held that Good Samaritan with no familiarity or pre-existing relationship to injured person cannot recover under Niet. On certification of question of law from district court summary judgment motion, SJC declined to permit recovery for Niet, where plaintiff was more than 1,000 miles away from the scene of accident when she learned of son's death by telephone. He died by telephone? How do you die by telephone? 7 hours after the airplane crash and never observed her son's body. Oh, he died by air crash, not by telephone. Niece's Niet claim. Next, defendant argues that John's niece, whom John was responsible for raising, cannot maintain a claim for Niet as a matter of law because the niece never observed Reed's conduct that caused John's death, nor observed his body at the hospital. If this court was to accept the defendant's position as true, some plaintiffs would never be able to satisfy such a standard, i.e., a blind person would not be able to see an accident or victim. A body reduced to ash in an explosion of fire would not be observable. Yeah, that's totally the same thing. Oh. She didn't observe the body, not because it was burned to cinders or because she was blind, because she never saw it. Two of these things cannot in any way be like. Oh. Yep. This is what I just read. That why didn't you put it in there that she was still distressed, but the family tried to shield her by not showing her John's body? But she still suffered the mental impact from it, even though she wasn't allowed to see it. Yep. Yet, nevertheless, experience a traumatic event with other senses that result in the individual suffering severe emotional harm or distress. Further, this assumption presumes that the niece was unable to experience the consequence of Reed's wrongdoing through other means such as sight, sound, interoception, and mind. What? Defendant's argument again fails to consider the totality of the circumstances present here, including when, where, and how the injury entered into the consciousness of the niece. While the niece may not have witnessed the initial collision, which resulted in John's injuries, she experienced firsthand the trauma, panic, and chaos that ensued shortly after. Within 4 hours of the collision and amid Reed's sustained wrongdoing, a vulnerable 14-year-old niece who had already lost both her parents, tragically was abruptly awakened at 4:30 by a hysterically screaming Karen Reed talking about hitting John with her SUV, involving the niece in phone calls about John being struck by a snowplow, and proclaiming that the niece's surrogate father, whom she had come to depend on, was dead. All this occurring, by the way, before John's body was discovered buried under the snow on the lawn on 34 Fairview. He wasn't buried under the snow. There was not snow enough to track a cat. Someone help me out here. Didn't the niece change her statement about what was said to her that morning? I can't remember, but I believe that because we couldn't hear her statements in either trial, but I think I heard somewhere that she changed her statements about what happened that morning, because she gave a statement. I think relying on, was it Aiden or was it Sue? Wasn't it something about she never really mentioned that part about how she said he got hit by something before? That seems well, get up to speed then. Yeah, something about I'm 100% sure that she changed her statements. Yeah, no, I know everything will come into a civil case, but still, I'm just, because everyone changed their statements in this case. That's the horrible part of this. No one has said the same thing twice in a row. And I'm pretty sure that Denise, when they talked to her in the beginning, didn't mention something about Karen screaming about being hit by a plow. But I'm not 100% sure. I'm not 100% sure. You might have to go to Aiden to get that confirmed. Yes, I might. But Aiden's busy, and we're 80 people here. Maybe some of you knows more than I do. And we're 5 people on Rumble. So almost combined 90 people. Some of us must know. Notwithstanding the fact that Kaylee did not physically observe the collision or John's body at the hospital, Kaylee witnessed firsthand Reed admitted to her wrongdoings and simultaneously perceived and experienced the gravity of harm caused by Reed through a sudden and overwhelming onslaught of sensory stimulation invading her consciousness. Or was it the part about Reed admitting to hitting him? There is something. Where's Sleuthy Goosey? She was here the last stream. Get back here. See, Kimino Supra. Emotional distress as the concept has evolved in this commonwealth is a severe psychological shock directly resulting from experiencing or witnessing the effects of a defendant's conduct. To suggest that the niece does not meet the lowest threshold of plausibly show that she is entitled to relief of NIT would be a blatant miscarriage of justice. Wherefore, defendant's motion to dismiss the niece's NIT claim must be denied. Plaintiff's complaint viewed holistically suggests that the O'Keefe family is entitled to relief to Reed's intentionally reckless infliction of emotional distress, so plaintiffs should be afforded the opportunity to conduct discovery. In seeking to dismiss the plaintiff's claim for reckless and or intentional infliction of emotional distress herein, defendants principally argues that the complaint lacks sufficient details to establish the elements of the claim and that the conduct alleged intra does not rise to the levels of extreme or outrageous to warrant recovery for EAD. In doing so, however, the defendants disregard the totality of the circumstances and all reasonable inferences constructed in the plaintiff's favor. The critical question is whether the claim viewed holistically is made plausible by the cumulative effect of the factual allegations contained in the complaint. requiring higher specific facts than the complaint is misplaced at the pleading stage and is reserved for summary judgment and trial. As the court has emphasized, notwithstanding the neoteric plausibility standard, no detailed factual allegations are required in a complaint. In evaluating whether the defendant's conduct was extreme or outrageous, the court should not isolate individual incidents, but rather should draw reasonable inferences from the totality of the circumstances, including whether the individual at whom the conduct is directed is known to be particularly susceptible to infliction of emotional distress. Further, the court should put a harsh face on the defendant's action as the basic facts would reasonably allow. There is an issue for the jury if reasonable people could differ on whether the conduct is extreme and outrageous. The defendant's motion to dismiss the O'Keefe family's claims for Ead should be denied because of their claims for need. That if plaintiff's intentional infliction of emotional distress claims require fact-intensive analysis based on the totality of the circumstances, which is more appropriate to address at summary judgment following completion of discovery. And then the niece's Ead claims. The defendant discounts two factors of critical importance in claiming that Reed's conduct directed towards the niece during the early morning hours of January 29th was not extreme or outrageous. Two, with the niece's age and vulnerability, the relationship of the plaintiff to the defendant and knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenged conduct satisfies the extreme and outrageous conduct requirement. A defendant's knowledge of plaintiff's vulnerability to emotional distress may compound the effect of the defendant's behavior, causing it to rise to the level of extreme and outrageous. Defendant alleges that the niece fails to state a claim for any infliction of emotional distress claims because the complaint does not clearly state what conduct applies to what type of claim. Plaintiffs are entitled to set forth multiple claims for relief, alternatively or hypothetically, regardless of consistency, so long as the claim viewed holistically are made plausible by the cumulative effect of the factual allegations contained in the complaint. Dismissal is not warranted. A complaint is not subject to dismissal if it would support relief on any theory of law. Furthermore, the same facts and allegations stated herein alternatively state a viable claim for NID on behalf of the niece in a non-bystander recovery context. Oh, and then I have to read this. A private investigator seeking information about a neighbor repeatedly contacted the plaintiff, who had asked him not to call and informed him that she had recently been discharged from the hospital. The allegation of repeated harassment in light of the plaintiff's known susceptibility to infliction of emotional distress stated a claim. Employer took advantage of employee with terminal big C. Elderly and frail neighbors might have been more susceptible to emotional distress as a result of the defendant's conduct. Denying motion to dismiss Ead claims where aides of plaintiff's children put defendant on notice of potential vulnerability to emotional distress when defendant neighbor brandished head clippers and threw plants in direction of the children. Why didn't I cover that case? Here, Karen Reed's relationship with the niece leading up to and including the time of her wrongful conduct is a key factor in considering whether the niece states a plausible claim for Ead. During her extended relationship with John, Reed inevitably played an important role in the 14-year-old niece's life as well. Reed explicitly knew that the niece was particularly susceptible to emotional distress, having already lost both of her parents tragically. Nevertheless, after striking John with her SUV in a state of intoxication and leaving him seriously injured outside in blizzard-like conditions, Reed returned to John's home and abruptly and hysterically awakened the niece in the middle of the night to talk about the unaliving of a person who the niece had come to depend on as a surrogate father since the tragic death of her own parents. Instead of calling 911 while John lay dying in the cold, Reed deliberately involved the niece in her plan to cover up her involvement by calling various acquaintances in front of the niece, proclaiming, among other things, that John never came home and that he may have been hit by a snowplow. There was a subnote. If there was no collision, as Reed claims, defendant's memo at page 2, and Reed simply left John unharmed at Fairview and returned home, why did Reed feel compelled to awaken young Kaylee in the middle of the night to tell her that her surrogate father was hit by a car or snowplow and was dead? And I believe that's the statement that changed from the first trial. Dave, I don't know if you can see it, but I'm reading. I don't have time to read both things at the same time. I'm not that ADHD. If Reed believed this to be true at the time, then her actions directed towards Kaylee that morning far exceeds the bounds of extreme and outrageous conduct. So if Karen didn't hit John O'Keefe and she woke her up and said, "Your dad hasn't come home. I hope nothing happened to him," she can be sued for emotional distress. You have too many lawyers in America, because that is absolutely ridiculous. With all the publicity of the criminal case, can Karen get her life back to where it was before? I don't believe so. No, she can't. Well, some of us do. I am always tossing bread at you, Squabby. But I believe that statement about how she said he was dead. Hey, Red House Media. Red House Media will be live in an hour and a half doing a Turtle Boy pre-show. If you need somewhere to go after this, hopefully I won't be reading for another hour and a half, because my voice will then be totally bonkers. Knowing that her words and action caused Denise severe emotional distress, Reed then stranded Denise home alone, shocked and frightened, with no one to comfort her. In reviewing Denise's Ead claim from the totality of the circumstances, Reed's alleged ongoing wrongful conduct in propagating her false narrative is discussed in more detail below, is also relevant to Kaylee's Ead claim because it reflects a prolonged pattern of calculated conduct designed to obfuscate the truth, to polarize the public, and to pit Reed and his supporters against the O'Keefe family. Why is that double spacing here? They do that sometimes. That's annoying. In drawing all reasonable inference from the totality of the circumstances, including Denise's age, vulnerability in relationship with Reed, and in placing as harsh a face on her actions as basic fact would reasonably allow, it is clear that reasonable people could differ on whether the conduct is extreme and outrageous. It is for the jury in such instances to decide whether Karen's conduct was rude and clumsy or extreme and outrageous. Therefore, the defendant's motion to dismiss must be denied. The O'Keefe's Ead claims. Like all other claims which defendant seeks to prematurely dismiss, the O'Keefe family's claims for Ead cannot be viewed in a vacuum. The court must evaluate whether the Ead claims reviewed holistically are made plausible by the cumulative effect of the factual allegation contained in the complaint, and drawing all reasonable inferences in the plaintiff's favor from the totality of the circumstances, including but not limited to the O'Keefe family's vulnerability to emotional distress resulting from the loss of a beloved son and brother. I bet you Peggy O'Keefe still cries every single night over losing the son she wasn't speaking to because she wanted to palm the kids off to him. I can't begin to understand how emotionally hard that must be for her, because yeah. The good thing about dying is everyone will then start loving you. All the people who couldn't care to come around when you were alive, they will be there for that day and the free coffee. The inconsistent citations is annoying. I don't read the case law because I don't know the case law, and I don't think anyone is going to go and look the cases up. But I'll read everything that they claim has to do with that and why it pertains to this. Poor kids, they know no one wanted them. Yeah, sadly, that was probably the worst thing about John's death that came forward after that. Is they found out John more or less was forced to take them because that old hack didn't want them. And by the way, they found out in court that their father died of an overdoses he took on their mother's grave. And information they were never given before. Will Hank Brennan or Adam Lally, whoever did the questioning, will they be sued for emotional distress for telling a 16-year-old girl that her dad went to her mother's graveside, sat down, and chose to inject enough drugs into his system that he passed away and not care enough about his kids to stay on this planet and take care of them? Of course not. Karen Reed's a bitch, you know that, right? But that asshole who told them that information they had never had before, he's the good guy. White hats all around. Hey, Karen Cole. Yeah, that everything, because can we get $5 more out of her? Yes, that should be what if they find as much as a nickel for this family. None of it should go to these assholes. It should be put in an account. And I have the same with this family, the way they treated these kids when John was still alive. Every single cent that might be awarded to this family if they win should be in an account for the kids. Just like Crystal Sorry, that POS, who's going to spend 2.3 million. All of that should have gone to her son because she didn't care when Harmony was alive. She cared when she was dead. I hate people like that. Brennan is a dirtbag. Yeah. Hey, Debbie. Oh, Helen for Holland, go to bed. Have a nice night. The core of the O'Keefe family's Eade claims allege that Karen Reed, knowing that she was responsible for causing John's death, calculatedly and maliciously fabricated a conspiracy and launched a public campaign of disinformation designed to obfuscate the truth and to deprive the O'Keefe family of justice for John, which has caused severe and profound emotional distress to the already grieving and vulnerable family. In support of her motion, defendant argues that the complaint lacks requisite factual avertments concerning the O'Keefe family's claim for Eade, and that plaintiffs cannot demonstrate as a matter of law that Reed's alleged conduct was intentionally directed towards the plaintiff, nor that such conduct was extreme or outrageous. First, there is no requirement that Reed intended her post-incident statements and conduct to cause emotional distress to the O'Keefe family. Although denominated an intentional tort, a review decision in which the cause of action has survived a motion to dismiss indicates that a majority of such actions are based not on conduct engaged in for the purpose of causing distress, but on conduct which the actor should have known would result in distress. Quinn v. Walsh. Neither is there a stringent requirement to plead highly specific facts or comprehensive allegation at this stage. Rodriguez-Reyes. Also, H.S. Howard Johnson. In holding dismissal of Eade claims was improper, the SJC noted that while many of her allegations were not particularly well stated, we believe that the plaintiff has alleged facts and circumstances which reasonably could lead the tier of facts to conclude that the defendant's conduct was extremely and outrageous, having a severe and traumatic effect upon plaintiff's emotional tranquility. Internal citations omitted. It would be highly inequitable for this court to dismiss the O'Keefe family's EAD claims for want of specificity at this stage, whereas Karen Reed holds the key to the evidence needed to prove those claims. Yet Reed has gone to great lengths to shield such evidence from discovery. No, she was in a criminal case. The stay of civil proceedings against Reed has only recently been lifted because the case ended, and the subject motion was served before plaintiff had any meaningful opportunity to conduct discovery, most notably Reed's deposition. Again, she was in a criminal case. Regarding the very claims Reed seeks to dismiss. Number 6. Plaintiffs propounded initial request for discovery on Reed via her counsel on or about July 24th. Where was the... This imbalance between the parties is precisely why generous and indulgent criteria has reduced the plaintiff's obstacle in surmounting a failure to state a claim to a minimal hurdle. Brum me dat more. The requirement of plausibility on a motion to dismiss simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Ocasio-Hernandez, quoting Bell Atlantic Corp v. Twombly, while plaintiffs believe that discovery from Reed will substantiate and expand upon their claims of a false narrative, a public filing, example A, is the affidavit of Detective Lieutenant Brian Tolley of the Massachusetts State Police, dated January 22, which details his investigation in support of a search warrant issued for Karen Reed's cell phones pertaining to allegation of witness interference and conspiracy. This affidavit is part of an opposition filed by Norfolk County's DA in Reed's criminal matter, which was not under seal. Plaintiffs acknowledged that Reed was not indicted for the aforementioned allegations. So you want her phone because it proves that she partook in a conspiracy that she was not indicted for. Yes. A public filing from Reed's criminal matters lends support to plaintiff's EAD allegations. According to the investigations of Brian Tolley following her arrest, Reed began using an old friend as an intermediary to covertly share information about defense theories in her criminal case with a now well-known blogger via an encrypted messaging application. According to Tolley, Reed began to secretly and selectively filter non-public information to the blogger for publication, including evidence, personal witness information, defense conspiracy theories, FBI involvement, and the impanelment of a federal grand jury. Reed also allegedly coordinated meetings between the blogger and her defense team, during which they discussed theories that other individuals were responsible for John's death, despite Reed's defense team claiming they never had any contact with the blogger. That's going to be interesting. I want to see that discovery. Reed eventually began communicating with the blogger directly and allegedly controlled what content the blogger would publish on his platform. This is interesting. So Aiden is going to give a deposition in this case as well. At various points in time, the blogger made public comments about influencing Reed's jury pool, arresting the people who killed John O'Keefe, and inferred during a rally that O'Keefe family's period of grief had expired and they were now fair game for trying to send an innocent woman to jail for the rest of her life. Media coverage regularly pitted the O'Keefe versus the Reeds, a product of what is believed to be a calculated campaign to polarize this case in the media and to portray anyone who questioned Reed's innocence as a villain. A simple internet search will reveal some of the disturbing consequences of Reed's false narrative, including but not limited to public and online harassment of the O'Keefe family, crowds of Reed followers callously booing the grieving family. That's a fucking lie. As they enter court, that's a lie. No one booed the O'Keefe family. Are you allowed to lie in a motion to the court? This has been debunked many times. Well, it's Massachusetts. You can lie whatever you want. The state will probably say the same. and taunting the O'Keefes by dancing in front of their home on video following Reed's acquittal of murder charges. It was a mentally ill woman that had nothing to do with Karen Reed who was dancing outside of that home. Can someone tell me how TMC's watermark was on that video? Because I watched JD and AH. There's only one type of videos where TMC puts their watermark on. That's videos they paid for. So if TMC put their watermark on that video, it's going to be interesting to see if the O'Keefe family sold that. Did they exploit a mentally ill woman for personal gain? The woman who was outside dancing is a known cray-cray. You are now using her to attack Karen Reed, who had nothing to do with her dancing. While at the same time, TMC put a watermark, and we know from the AHJD case, they only put that on videos they paid for because then they can claim copyright on them. How did KP have the video without the watermark? How did Krusty have access to O'Keefe video the same day this allegedly happened? Who is using the media? Who is writing these motions so you can sound clip them or soundbite them and put them on the twit? This is other BS. Other BS. Where did we go? That was number 9. Sorry. Without repeating the relatively minimal threshold for overcoming a motion to dismiss, a reasonable jury could conclude that Reed knew or should have known that she would cause severe emotional distress to an already grieving O'Keefe family when she struck their son and brother with her SUV. Still, no one knows she did that because it hasn't been proven. But it's civil. It does matter if you can cry on the stand. Left John gravely injured to die in the cold and deliberately contrived a conspiracy theory and orchestrated a public campaign of disinformation to shift the blame to innocent parties and deprive O'Keefe family of truth and justice for John O'Keefe. I never talked to Aiden Turtleboy Carney till I had him on my show a couple of months before the first trial. I have held the opinion since I saw the very first hearing in the case that Karen Reed was massively overcharged. In the beginning, before we saw the evidence, I could maybe have gone with could potentially have been maybe a manslaughter accident. Then we got into the case, saw the evidence. And there's no evidence from anyone that even suggests John O'Keefe was struck by a car. No evidence. If Karen Reed is the one who put this conspiracy theory together, how did I arrive at the same conclusion like almost every other streamer who watched the pre-trial hearings, the first trial, the between trial hearings, and the second trial, that there is no evidence that proves John O'Keefe was struck by an SUV. If all of this relies on Karen Read's media campaign, a really bad media campaign because all the MSM was on the O'Keefe side. If I had lived in Massachusetts and didn't know about the YouTubes, I would believe that Karen Read did it. If I watched Court TV, the biggest coverage on true crime on this case, well, Emily D. Baker probably bigger. I would have believed Karen Read was guilty as sin because Miss Botox sits every morning yammering that Karen Read did it. But everyone else arrived at the exact same conclusion I did. There was no evidence to sustain a second-degree murder charge. But they want you to believe that without Aiden Turtleboy influencing me, the lawyer you know, Mike from the Young Jerks, Emily D. Baker, Andrea Burkhardt, Runkle of the Bailey, Harry in Germany, Alles nur geklaut. Go look him up if you want to learn German. Legal Vices when he still lived in Korea, all around the world. All of these people arrived at the exact same conclusion. Karen Read did not hit John O'Keefe with her car. And how did we arrive there? By Turtle Boy yelling at us? No. By looking at the evidence shown in court, filed in motions that never made sense. I made a Lego video showing how this could not have happened. I did that before for the first trial. I did it before I spoke with Aiden the first time because I read the motions on what Jen McCabe explained happened that night, and none of it made sense. But this lawyer wants you to believe that because Karen Read, and even if she collaborated with Aiden, she's allowed to do that. She's allowed to call the Boston Globe and say, hey, my side of the story. But how can everyone, except probably less than 10,000 people, still believe Karen Read hit John O'Keefe? My daughter didn't get into Karen Read till the second trial. She called me and said, hey, that Karen Read case you're covering, is it good? She was at home with my grandson. I said, yeah, I think you should watch it. She said, don't tell me what it's about. I said, well, it's about a woman who's accused of hitting her boyfriend with a car. Yeah, but I don't want to know your take on it. I want to watch it. She called me back 2 days later because she was like 14 days after we started, said, are they ever going to put any evidence up there that she did it? I said, well, if you see it, you tell me. My daughter don't know who Aiden Turtleboy is. She never, ever watches. The only true crime she watches is me. And she didn't know who Karen Read was. How can everyone arrive at the exact same conclusion if all of this is a mastermind, Karen Read and Aiden Turtleboy, who planted in our head? Yeah, that makes sense in a reasonable world. She had 67 drinks in 2 hours plus the snow means the guilties, all the guilties. Yeah, Jeff was on it as well. Microdot did an amazing job with the evidence as well. Yeah, a lot of great people needs a lot of recognition. Well, hopefully she's biased that her dad is the greatest streamer in the world. No, she doesn't watch me. They never stated that they saw the body. That's actually why Karen Read wants them to dismiss it. Reed's lawyer did a good job convincing 16 out of 24 jurors that Reed didn't hit John O'Keefe beyond a reasonable doubt. Well, they did a good enough job to convince 24 people because no one believed she did it. The guilty in the first trial was on the DUI part. It had nothing to do with the murder too. Yeah, rest in peace, Jeff. He was supposed to have been on my show the very next week when he died. That was a big surprise. I talked to him and was looking forward to talking to him again because the last time I talked to him, he had been a little too drunk. Yeah, exactly what I said. Go back, read the jurors who came forward. No one believed murder 2 was ever on the table. No one believed leaving the scene of an accident. They were only discussing the OUI. It's not that hard if you just listen. No, they were not. Go back, listen to what they said, and everyone agreed no manslaughter, no second degree, no leaving the scene. I am not wrong. You're wrong. The plaintiff acknowledged that the circumstances in this case was exceptional and certainly distinct from any Iat case relied upon by the defendant. C. Polai SJC held motion to dismiss Iat claim was proper because a single verbal attack or surviving a home did not rise to the level of extreme outrageous. However, the court did not consider the finding of false police reports on harassment petition in the analysis because they were privileged under the anti-SLAPP. Affirming motion to dismiss. What the hell? Did they cut off a footnote? Affirming the motion to dismiss. Where's the rest of that footnote? Is it this one? Holding that garden variety adultery in our society does not constitute conduct which is extreme and outrageous. What the hell is this about? Finding no extreme or outrageous conduct where employer reinstated plaintiff's employee's job after being acquitted of false charge, even though employee was assigned to different location with an uncomfortable work environment. I don't know what that footnote is about. Which only favors the view that a Rule 12 motion is an improper means to challenge of the O'Keefe family's Iat claims. The jury, not this court, should resolve whether Reed's conduct was extreme and outrageous under the totality of circumstances in this case. There is an issue for the jury if reasonable people could differ on whether the conduct is extreme and outrageous. We've heard that a million times. At a minimum, the O'Keefe family deserves a fair opportunity to complete the discovery needed to prove their Iat claims. Wherefore, the plaintiff respectfully requests that this honorable court deny defendant Reed's motion to dismiss in its entirety and to allow the plaintiffs an opportunity to conduct discovery because the plaintiffs had averred plausible claims for relief against Karen Reed for infliction of emotional distress. Should this court determine that plaintiff's complaint fails to state a claim in any respect, the plaintiffs respectfully request that this court grant them leave to amend the complaint following the completion of discovery in order to cure the deficiencies. If any, the plaintiffs respectfully request a hearing on this matter. And this is by Mark Diller. Diller in Danish means pee-pee. So this guy in Danish would be Mark Diller, Mark pee-pee. I'm taking a photo. So this man is called Mark Penis. Let's get to Karen Reed's reply to the O'Keefe's reply. Defendant Karen Reed's reply to plaintiff's opposition to her motion to dismiss counts 10, 11, 12, and 13 of the plaintiff's complaint pursuant to MRCP 12B6. Defendant Reed hereby submits this reply to certain of the arguments set forth in the plaintiff's opposition to her motion to dismiss counts 10, 11, 12, and 13 of the plaintiff's complaint pursuant to Mass P12B6. Reed's decision to address only some of the arguments set forth in the plaintiff's opposition should not be deemed as acquiescence in or acceptance of those arguments that are not responded to herein. Instead, Reed relies on her initial moving papers on such topics. First, the plaintiff's opening salvo that Reed intentionally styled her partial motion to dismiss as a motion to dismiss the entire complaint from media attention is not in any way supported by the record, nor does such contention add anything of substance to plaintiff's argument. The irony is not lost on Reed here, where plaintiffs contend that her pleadings are presented strictly for sensationalism. Second, the content that Reed calculated and maliciously fabricated a conspiracy launched a public campaign of disinformation designed to obfuscate the truth and to deprive the O'Keefe family of justice. The decedent, John O'Keefe, is not supported by any factual advertisements. In their opposition, plaintiffs attach an affidavit in support of a search warrant authored by a state trooper acknowledging that Reed was not indicted for any crimes pertaining to the warrant. See plaintiff's opposition to motion to dismiss 7 and 7. We just read that. The document should be disregarded because it was not an exhibit to the complaint, does not pertain to plaintiff's emotional distress claims, and does not reference any plaintiff within. See Polly v. McMahon, 468, Massachusetts, blah, blah, blah. Share v. Brandeis University, Brandeis, noting the complaint could have been dismissed for a failure to state a short and plain statement of the claim pursuant to Mass Civil Law P8A1. Also in their opposition, plaintiffs argue they should first be entitled to conduct discovery to develop necessary facts before their emotional distress claims are dismissed. This runs contrary to Massachusetts Civil Procedure 8. For the purpose of this motion, the court should consider what has been averred within the four corners of the plaintiff's complaint and determine whether it contains sufficient fact to give rise to the claims pleaded herein. Here, the complaint failed to aver necessary facts beyond conclusory allegation of emotional distress claims. If the plaintiff wished to investigate potential emotional distress claims, then pursuant to Mass Civil Procedure 15, they may subsequently amend their complaint if they are one day able to develop the supposed facts. Third, contrary to the plaintiff's mischaracterization, at no point has Reed or her counsel sought to disrupt or obstruct the plaintiff's ability to engage in discovery. In fact, it's been a long day. In fact, plaintiffs has largely avoided taking any discovery other than efforts intended to affect Karen Reed's defense at her second criminal trial. On August 26, plaintiffs filed their lawsuit against Karen Reed and two co-defendants. On October 1st, before serving a request for written discovery on any defendant, plaintiffs noticed Reed's audiovisual deposition to occur on December 4th, notwithstanding the fact that she awaited the start of a second criminal trial stemming from the death of John O'Keefe. In light of her right to be free from self-incrimination as guaranteed by the United States Constitution, Reed appropriately moved for a protective order to stay any and all discovery of her until after the conclusion of her second criminal trial. That motion was probably granted by this court on October 31st. Reed's parents, William and Janet Reed, as well as her sister-in-law, Caitlin Baudreux, were hurriedly subpoenaed on January 29th and March 8th for their respective audiovisual depositions to occur on the eve of Reed's second criminal trial. As of March 8, plaintiffs had not served any written discovery on the co-defendants or sought to take fact witness depositions of anyone other than Reed's immediate family. William and Janet Reed and Caitlin Baudreux through counsel, appropriately requested a stay of their depositions until after their daughter's sister-in-law's second criminal trial concluded, which was granted by this court. On June 20th, the second trial ended with Reed being found not guilty of any act that involved the death of the decedent John O'Keefe. With the stay then lifted on July 9th, Reed served her motion to dismiss counts 10, 11, 12, and 13 of the plaintiff's complaint. On July 24th, plaintiffs served a request for documents of Reed. This was the first request for discovery served on Reed since the stay lifted. Reed will respond to this and all discovery obligation in a timely manner consistent with the rule of civil procedure. But any allegation that Reed has acted in a manner to deprive plaintiffs of engaging in discovery is unfounded. To date, plaintiffs made a strategic decision not to pursue discovery. Moreover, the plaintiffs have not been prejudiced by their own inaction, particularly where the discovery deadline expires in August 2026. Wherefore, the defendant Karen Reed respectfully requests this court allow her motion to dismiss 10, 11, 12, and 13 by her attorneys, William Kerville. Alan Jackson is not on this one. No. And co-signed by the bars. That was a long one. That's what she said. You like that reply? I liked it too because they hit the nail on the head. Because I know it's a civil case and the rules is a little lighter in that one. And you can always try and sneak something in there. But how have they not served deposition orders on the bars yet? Shouldn't they have called people from the bar when they are suing the bar as well? Why haven't they taken their depositions? I'm not saying this is made in, because then it will be just like them claiming that Aiden and Karen are working together. I'm not saying this is made in some kind of collaboration with the Commonwealth. But isn't it funny that they cry now that they couldn't get the deposition? They haven't even asked for it after Karen Reed was found not guilty. They never took depositions on any of the people at the bar. Why haven't they taken their depositions? Talk about how drunk Karen Reed was. Isn't that really important? You could have put that in there saying, we have depositions that she was drunk as a skunk. She wasn't quite orange-free, as we say in Denmark. Nope, not important. The only people they wanted deposition from was Karen Reed, which they knew they couldn't get because she was waiting a second criminal trial, and no judge would have allowed that because it will be in conflict with her Fifth Amendment rights. And her parents, who had nothing to do with the accident, the only thing is they picked her up at the hospital. And her sister-in-law. Those are the depositions they have sought so far because they really, really want to get to the bottom of this. Because the emotional distress they have suffered. The horrible Aiden. The horrible Karen Reed. The horrible Jew. Why did you do this to them? I'm saying she's a gold digger, but I've never seen her file a deposition. T-Rex, sometimes I miss Kimmy on days like this. Her text from the other side. Interesting. I miss Kimmy because I was this close to finally get someone to send me some nudes. That's not Zach. I am sure me and Kimmy are soulmates, and one day we will meet, and love will spring from it. Prima didn't hesitate on the Roman numerals, multilingual. No, I went to school, so we had to learn the first 10, and 10 is just, yeah, it's the easy ones we had. I don't know 15. Yeah, I figured that one out, T-Rex, but thank you anyway. You're wrong. You don't know those fancy numbers. Well, those fancy numbers have been around for almost probably 2,500 years. Most clocks have them on them, so it's not that hard. But yeah, and it's really easy. You always subtract for the bigger number. So I V V I V I V I X X X I. It's really easy. No, you're right. Oh, I'm wrong. Sorry. I know. Was it Boston Globe you cited it from? Yeah. See you later. And one juror has talked about it, and you know what they said? It was never on the table. 3 articles. 3 articles. Well, then you get to M, you get to C. I don't know those ones. But I like the response. It was short and sweet. Hey, you're the assholes who want to turn this into a media circus because you claim you were really searching for all of this evidence that can prove that you're mentally, emotionally hurt, but you haven't done shit since the ban was lifted on talking to the Reed and her family. You never ever contacted the boss. Again, I am sure that family is suffering greatly. And they are crying every single day. And if Jamie would have been here, it's her phone day today. But if she's been here because she's a mean, nasty person, she probably would have said, including the bar seems like a money grab because they would probably, the insurance companies, make a, hey, we are not at fault, but we're going to give you $25,000 and get out of there because they don't want to play with that. If they can just sign over a check and say we have no liability, that's what happens in a lot of cases. That is what Jamie would have claimed. This was just a money grab from the boss. That's why they included them. But just like when the Commonwealth jumped on Karen Reed and upcharged her, that lady had balls. And that lady knew how to get good lawyers. So good lawyers that even the boss joined her team. I think in most cases, those bars would have been in, out with a settlement, 25,000, see you later. don't talk about it. We have no fault. But now they are even Team Reed because let's see how ridiculous this is. Oh, I didn't know that. I don't know those numbers. Why did it repeat itself? Yeah, they picked the wrong girl because this girl is a fighter. This girl, who is a woman, doesn't lay down. And this woman, with her tenacity and her massive set of balls, have gotten some of the greatest lawyers on her side. I don't know who the O'Keefe have on their side. It's still a civil suit. The bar is way lower in a civil suit. But what I just read makes it clear to me that they are going to send a teenager in to cry in the court, hoping the tears turn into gold. Because that bullshit about Karen Reed making a motion for the media is something I expect Twisted Tragedies, Mama Lama, Braden, Aiden, whatever his name is, and Krusty to put on their twits today. Oh, Karen Reed is just doing it for publicity. Because talk about marching orders. And I still want to know, and this is the discovery I want. I want discovery of that dancing video. I want to see the deposition of Peck. I think she's the one who lives in the house now. I want to see the deposition of her when she explains to me how a TMC watermark video, which means they paid for it, got on the interwebs. How did her Ring camera video alleging a Karen Reed supporter was harassing them get sold to TMC? Does anyone else have access to your Ring system? Because back in the day, only John's phone had access. And how did Krusty Panties, the queen herself, have the video without the watermarks? Are you collaborating with Krusty in any way? That's the deposition I want them to take. Because this family, I don't know. If Jamie had been here, she would say something nasty, but I don't do that. I feel for them. In a civil suit, the jury will know Arca was hired by the feds. They can bring that up, yeah. But causation is going to be a huge problem for them. I think a lot of things is going to be a very huge problem for them because how do you determine this girl's mental problems or emotional damage stems from that? Not from Hank Brennan telling her, hey, did you know your dad overdosed because he couldn't, because he missed your mom? He didn't give a F about you. He didn't want to stay on this planet. He just jumped off it. Could that potentially, are they going to sue the Commonwealth for putting them in that position? Of course not, because this has everything to do with them trying to break Karen Reed's Fifth Amendment rights so the Commonwealth could get their win, is what Jamie would have said. I want some more McAlbert text. I want a lot of things. Brennan is cringe. He is horribly cringe. But he still made more money than I did out of the Karen Reed case. And I grifted a shit ton on it. But still, I couldn't make the money he could by just showing up to court saying, I don't know. And no one knew when, where, or how she hit John O'Keefe. But you must find her guilty, as he ended his closing arguments. But I want to leave you all with our lovely troll. It's a new troll we have today. Still doesn't make them right. It's just always nice to have a new viewer. And they had to sub to write in the chat, hopefully. I did my first stream 18 hours ago. It's almost midnight. I'm going to find somewhere to send you. If I think Turtle Boy has a stream later tonight. That's going to be at 9 o'clock normally. And you can go check that out. Other than that, there is Red House Media is doing a Turtle Boy upcoming show. And AJ is looking at Betty Broderick, all in not that long. Other than that, I don't think anyone else really is going now. You should be back home eating your dinner and getting ready to spend the night in front of the TV. That was my plan, but instead I spent it with you, which makes me happy because I like you peoples. You are good peoples. Well, some of you are, but I'm going to send you there. Have a wonderful night. Dear Keeves. Jeepers.
What exhibit are you referring to? I'm going to make this 100, Your Honor. All right. 100.
100.
Because it is 100%
100%.
correct.
Objection, Your Honor. So you literally built a cannon?
Yeah, it's pretty awesome.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.
So there.
Everybody has.
T-Rex, normally you are always too early. That's what the ladies say at the lot. But thank you so much. Come on, Baker. We know exactly how Karen hit John O'Keefe. I seem to recall something about Alexis being able to blast off into space. That's how she did it. And traveling at multiple times the speed of light. T-Rex, thank you so much. You get to sign off the stream. Well, you should come around more often. You'll figure out that I'm the biggest asshole on the planet and I'm not a gentleman. And I'm not conceding because you are fucking wrong. And I don't give a fuck about you stupid trolls who hate Karen Reed. Get a fucking life. 2 juries found her not guilty in manslaughter. And you're, oh, they didn't file a motion to dismiss the murder charge. They actually did. You're an idiot. We had 2 trials. Not guilty, not guilty, not guilty. A $2 million trial to get an OUI. You must be too stupid to tie your Velcro shoes if you keep harboring on about Karen Reed. Get a life. Move on. She doesn't know you. She is never going to care about you. And you're not a white knight for the McAlberts or the O'Keefe family, whoever you think you're impressing. Go back to the crusty hole. Good night.